All right, welcome back to the Daily Facts, and this is part two of the read through of the indictment that or lawsuit that Sidney Powell dropped on Georgia. So let's get right into it. Plaintiff Vicky Townsend Consiglio is a registered voter who resides in Henry County, Georgia. She is a nominee of the Republican Party to be a presidential elector on behalf of the state of Georgia. Plaintiff Gloria K. Goodwin is a registered voter who resides in Pierce County, Georgia. She is a nominee of the Republican Party to be a presidential elector on behalf of the state of Georgia. Plaintiff James Kenneth Carroll is a registered voter who resides in Dodge County, Georgia. He is a nominee of the Republican Party to be a presidential elector on behalf of the state of Georgia. Plaintiff Carolyn Hall Fisher is a registered voter who resides in Forsyth County, Georgia. She is a nominee of the Republican Party to be a presidential elector on behalf of the state of Georgia. Plaintiff Kathleen Alston Latham is a registered voter who resides in Coffee County, Georgia. She is a nominee of the Republican Party to be a presidential elector on behalf of the state of Georgia. Plaintiff Brian J. Van Gundy is a registered voter in Gwinnett County, Georgia. He is Assistant Secretary of the Georgia Republican Party. Defendant Governor Brian Kemp, Governor of Georgia, is named herein in his official capacity as Governor of the state of Georgia. On or about June 9, 2019, Governor Kemp bought the new Dominion voting systems for Georgia, budgeting $150 million for the machines. Critics are quoted, led by Abrams, Democrats fought the legislation and pointed to cybersecurity experts who warned it would leave Georgia's elections susceptible to hacking and tampering. And just this week, the Fair Fight voting rights group started by Stacey Abrams launched a television ad critical of the bill. In a statement Thursday, the group called it corruption at its worst and a waste of money on hackable voting machines. Defendant Brad Raffensperger, Secretary Raffensperger, is named herein in his official capacity as a Secretary of State of the state of Georgia and the chief election official for the state of Georgia pursuant to Georgia's election code and OCGA 21-2-50. Secretary Raffensperger is a state official subject to suit in his official capacity because his office imbues him with the responsibility to enforce the election laws. Grizzle versus Kemp, 634 F 3D 1314 1319, 11th Circuit 2011. Secretary Raffensperger serves as the chairperson of Georgia's State Election Board, which promulgates and enforces rules and regulations to obtain uniformity in the practices and proceedings of election officials, as well as legality and purity in all primaries and general elections, and be conducive to the fair, legal, and orderly conduct of primaries and general elections. See OCGA 21-2-30, 21-2-31, and 21-2-33.1. Secretary Raffensperger, as Georgia's chief elections officer, is further responsible for the administration of the state laws affecting voting, including the absentee voting system. See OCGA 21-2-50B. Defendants Rebecca N. Sullivan, David J. Worley, Matthew Mashburn, and Anna Lee, hereinafter the State Election Board, are members of the state election board in Georgia responsible for formulating, adopting, and promulgating such rules and regulations consistent with law as will be conducive to the fair, legal, and orderly conduct of primaries and elections. OCGA 21-2 31-2. Further, the election board promulgates rules and regulations to define uniform and non discriminatory standards concerning what constitutes a vote and what will be counted as a vote for each category of voting system in Georgia. OCGA 21-2 31-7. The state election board personally and through the conduct of the board's employees, officers, agents, and servants acted under color of state law at all times relevant to this action and are sued for emergency de- declaratory and injunctive relief in their official capacities. Jurisdiction and venue. This court has subject matter jurisdiction under 28 U.S.C. 1331, which provides the district courts shall have original jurisdiction of all civil actions arising under the Constitution, laws, or treaties of the United States. The court forgive me. The court also has subject matter jurisdiction under 28 U.S.C. 1343 because this action involves a federal election for President of the United States, a significant departure from the legislative scheme for appointing presidential electors presents a federal constitutional question, Bush versus Gore, 531 U.S. 98 113 2000, Rehnquist, C.J. concurring, Smiley versus Holm, 285 U.S. 355 365, 1932. The jurisdiction of the court to grant declaratory relief is conferred by 28 U.S.C. 2201 and 2202 and by Rule 57 and 65, Federal R. Civil P7. This court has jurisdiction over the related Georgia constitutional claims and state law claims under 28 U.S.C. 1367. In Georgia, the legislature is the General Assembly. See GA Constitution Article 3, Paragraph 1. Because the United States Constitution reserves the state legislators the power to set the time, place, and manner of holding elections for Congress and the President, state executive officers, including but not limited to Secretary Raffensperger, have no authority to exercise that power unilaterally, much less flout existing legislation or the Constitution itself. Statement of facts. Plaintiffs bring this action under 42 U.S.C. 1983 and 1988 and under Georgia law OCGA 21-2 522 to remedy deprivations of rights, privileges, or immunities secured by the Constitution and laws of the United States and to contest the election results. The United States Constitution sets forth the authority to regulate federal elections. The Constitution provides the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. But the Congress may at any time by law make or alter such regulations except as to the places of choosing senators. U.S. Constitution, Article 1. 4. Elections Clause. With respect to the appointment of presidential electors, the Constitution provides each state shall appoint in such manner as the legislature thereof may direct a number of electors equal to the whole number of senators and representatives to which the Senate may be entitled in the Congress, but no senator or representative or person holding an office of trust or profit under the United States shall be appointed an elector. U.S. Constitution, Article 2, 1. Electors Clause. Okay. Neither defendants is a legislature as required under the Elections Clause or Electors Clause. The legislature is the representative body which makes the laws of the people. Smiley 285 U.S. 365. Regulations of congressional and presidential elections thus must be in accordance with the method which the state has prescribed for legislative enactments. ID at 367. See also Arizona State Legislature versus Arizona Independent Redistricting, 576 US 787 135, SCT 2652 2668 US 2015. When the Elections Clause was not adopted to diminish a state's authority to determine its own lawmaking processes, Arizona State Legislature 135S CT at 2677, it does hold states accountable to their chosen processes when it comes to regulating federal elections, ID at 2668. A significant departure from the legislative scheme for appointing presidential electors presents a federal constitutional question. Bush 531 U.S. at 113. Rehnquist C.J. concurring. Smiley 285 U.S. at 365. Plaintiffs also bring this action under Georgia law OCGA 21-2-522 grounds for contest. A result of a primary or election may be contested on one or more of the following grounds. 1. Misconduct, fraud, or irregularity by any primary or election official or officials sufficient to change or place in doubt the result. 2. When the defendant is ineligible for the nomination or office in dispute. 3. When legal votes have been received or legal votes rejected at the polls sufficient to change or place in doubt the result. 4. For any error in counting the votes or declaring the result of the primary or election, if such error would change the result. Or 5. For any other cause which shows that another was the person legally nominated, elected, or eligible to compete in a runoff primary or election. OCGA 21-2-522. Under OCGA 21-2-10, presidential electors are elected. Under OCGA 21-2-386A1B, the Georgia legislature instructed the county registrars and clerks, the county officials, to handle the absentee ballots as directed therein. The Georgia legislature set forth the procedures to be used by each municipality for appointing the absentee ballot clerks to ensure that such clerks would perform the duties set forth in this article. See OCGA 21-2-380.1. The Georgia Election Code instructs those who handle absentee ballots to follow a clear procedure. Upon receipt of each absentee ballot, a registrar or clerk shall write the day and hour of the receipt of the ballot on its envelope. The registrar or clerk shall then compare the identifying information on the oath with the information on file in his or her office, shall compare the signature or make on the oath with the signature or mark on the absentee elector's voter card or the most recent update to such absentee elector's voter registration card and application for absentee ballot or a facsimile of said signature or marker taken from said card or application, and shall, if the information and signature appear to be valid and other identifying information appears to be correct, so certify by signing or initialing his or her name below the voter's oath. Each elector's name, so certified, shall be listed by the registrar or clerk on the numbered list of an absentee voters prepared for his or her precinct. OCGA 21 2 386A1B. Emphasis added. All right. Under OCGA 21 2 386A1C, the Georgia legislature also establishes a clear and efficient process to be used by county officials if they determine that an elector has failed to sign the oath on the outside envelope enclosing the ballot, or that the signature does not confirm with the signature on file in the registrar's or clerk's office, a defective absentee ballot. The Georgia legislature also provided for the steps to be followed by county officials with respect to defective absentee ballots. If the elector has failed to sign the oath, or if the signature does not appear to be valid, or if the elector has failed to furnish required information or information so furnished does not conform with that on file in the registrar's or clerk's office, or if the elector is otherwise found disqualified to vote, the registrar or clerk shall write across the face of the envelope rejected, giving the reason therefor. The Board of Registrars or absentee ballot clerk shall promptly notify the elector of such rejection, a copy of which notification shall be retained in the files of the Board of Registrars or absentee ballot clerk for at least 1 year. OCGA 21 2 386A1C. Emphasis added. Defendants' unauthorized actions violated the Georgia Election Code and caused the processing of defective absentee ballots. Notwithstanding the clarity of the applicable statutes and the constitutional authority for the Georgia legislature's actions, on March 6, 2020, the Secretary of State of the state of Georgia, Secretary Raffensperger, and the State Election Board, who administer the state elections, the administrators, entered into a compromise and settlement agreement and release, the litigation settlement, with the Democratic Party of Georgia, Inc., the Democrat Senatorial Campaign Committee, and the Democratic Congressional Campaign Committee, collectively the Democrat Party agencies, setting forth different standards to be followed by the clerks and registrars in processing absentee ballots in the state of Georgia. Under the settlement, however, the administrators agreed to change the statutorily prescribed manner of handling absentee ballots in a manner that is not consistent with the laws promulgated by the Georgia legislature for elections in the state. The settlement provides that the Secretary of State would issue an official election bulletin to county administrators overriding the statutory procedures prescribed for those officials. That power, however, does not belong to the Secretary of State under the United States Constitution. The settlement also changed the signature requirement, reducing it to a broad process with discretion rather than enforcement of the signature requirement as statutorily required under OCGA 21 2 386A1. The Georgia legislature instructed county registrars and clerks, the county officials, regarding the handling of absentee ballots, and OCGA S 21 2 386A1B 21 2 381. The Georgia Election Code instructs those who handle absentee ballots to follow a clear procedure. Under receipt of each absentee ballot, a registrar or clerk shall write the day and hour of the receipt of the ballot on its envelope. The registrar or clerk shall then compare the identifying information on the oath with the information on file in his or her office, shall compare the signature or make on the oath with the signature or mark on the absentee elector's voter card or the most recent update to such absentee elector's voter registration card and application for absentee ballot, or a facsimile of said signature or marker taken from said card or application, and shall, if the information and signature appear to be valid and other identifying information appears to be correct, so certify by signing or initialing his or her name below the voter's oath. OCGA S 21-2-386A 1B. The Georgia legislature prescribed procedures to ensure that any request for an absentee ballot must be accompanied by sufficient identification of the elector's identity. See OCGA 21-2-38 1B1, providing in pertinent part in order to be found eligible to vote an absentee ballot in person at the registrar's office or absentee ballot clerk's office, such person shall show one of the forms of identification listed in Code Section 21-2-417. An affiant testified under oath that it was also of particular interest to me to see that signatures were not being verified and that there were no corresponding envelopes seen in sight. Attached here too, as Exhibit 10, Mayra Romero at Part 7. To reflect the very reason for process, it was documented that in the primary election prior to the November 3rd, 2020 presidential election, many ballots got to voters after the election. Further, it was confirmed that untold thousands of absentee ballot requests went unfulfilled, and tens of thousands of mail ballots were rejected for multiple reasons, including arriving too late to be counted. See the Associated Press, Vote by Mail Worries, a leaky pipeline in many states, August 8, 2020. Pursuant to the settlement, the administrators delegated their responsibilities for determining when there was a signature mismatch by considering in good faith only partisan-based training. Additional guidance and training materials drafted by the Democrat Party agencies representatives contradicting OCGA 21-2-31. Unlawful early processing of absentee ballots. In April 2020, the State Election Board adopted on a purportedly emergency basis Secretary of State Rule 1831-14-0.9-15, processing ballots prior to Election Day. Under this rule, county election officials are authorized to begin processing absentee ballots up to 3 weeks before Election Day. Thus, the rule provides in part that 1. Beginning at 8 a.m. on the third Monday prior to Election Day, the county election superintendent shall be authorized to open the outer envelope of accepted absentee ballots. Emphasis added. Okay, we're going to end it there and we'll pick up on part 3 very soon. Thanks for stopping by the Daily Facts. Do like, share, subscribe, and leave a comment below, and we'll talk again soon. Bye.